In order to have a dispute resolved fairly, we often turn to litigation. In that pursuit, we expect that the person who leads the court proceeding to be fair and unbiased, finds the facts, decides what really happened, and then applies the appropriate laws to the facts to reach a decision. Sometimes that process does not unfold as it should. This timeline illustrates 5 separate cases spanning over 4 years that I brought in the state and federal court systems in New York due to being unlawfully discharged. These claims are against my former employer, the New York State Unified Court System, and named employees of that state agency. First, I will give a brief overview of my 2 federal and 3 state cases and why I found it necessary to commence these actions. Afterwards, I will briefly describe how each resulting proceeding was unlawful, fraudulent, and therefore unconstitutional. I'm Jean, and here's why I'm suing. For constitutional rights violations, for Equal Employment Opportunity Commission violations, for Section 1983 violations, for retaliation, for crimes that violate federal statutes and state laws, and I added conspiracy against rights to my most recent lawsuit due to how my adversaries conducted fraudulent proceedings for the cases that preceded it. The defendants in all these lawsuits are court employees who oversee and operate the state court system. A little later in the video, I will expound upon the actual events that precipitated these lawsuits. Let's begin with my first case in May of 2020. The unified court system having forced me into taking legal action to resolve the violations that I outlined led me to King's Civil Supreme Court in Brooklyn, New York. Upon arrival, court clerks directed me to the Court of Claims in Albany. Not having any prior experience with this, I submitted my notice of claims to that court, thinking it needed to be validated with a claim number. Instead of rejecting my notice of claim or returning it to me, the Court of Claims took 4 months to process that document. In September of 2020, I received correspondence in the mail from the Court of Claims assigning a claim number and a judge to my notice of claim. In the letter, I was also directed to continue to file all pleadings with the clerk's office in Albany, even with them acknowledging that my claims accrued in Kings County. Proceeding as they instructed, I filed my claim there in October to initiate my lawsuit. I brought the remaining lawsuits to remedy the original harm and to seek legal redress for the obstruction of due process of law that took place in each proceeding. My second lawsuit I commenced in June of 2020. I knew that this was the court where I should file my lawsuit, so I erred on the side of caution, returned to King's Civil Supreme Court, and filed a case there in June, when by that time the Court of Claims had not sent any follow-up notification concerning my visit. My third lawsuit I commenced in August of 2021. King's Civil Supreme Court had the case that I filed there in June of 2020 pending for over 1 year before they assigned it to a judge who lacked jurisdiction. Despite my protests, they refused to transfer my case to the proper jurisdiction and the venue pursuant to the law. I filed this lawsuit in the Eastern District of New York, and for reasons that the court never explained, they transferred the case to the Southern District of New York, assigning it this new case number. I commenced my fourth lawsuit in March of 2022. After consulting with an attorney concerning the outcomes of my previous cases and the root of the matter, she suggested pursuing a discrimination lawsuit in state court. In my fifth and current lawsuit, I initiated in January of 2023 to remedy the original harm and a multitude of other violations stemming from my previous cases, to include conspiracy against rights. So, what actually happened? Why sue? I want to prove what I'm alleging, and what the facts point to is that two of my immediate supervisors at that time, Toya Young and Frank Shea, who was also my union delegate, used a fraudulently created document containing fabricated charges complete with a forged signature and presented it to me in the form of a termination letter, claiming it was from Judge George J. Silver, the Deputy Chief Administrative Judge for New York City courts at that time, to personally and unlawfully discharge me from employment from the unified court system. This means that on February 18th of 2020, close to the end of the workday, around 5 p.m., without warning, and anyone of authority present, to include anyone from Human Resources, the chief clerk for that courthouse, or our overall supervisor. The only other court personnel present were other court officers, which is what I was before being unlawfully discharged, that Young and Shea performed this act in front of. What's more, I realized later that the letter that they presented to me wasn't even in compliance with the New York State Department of Labor laws. Between February 18th and May of 2020, I tried communicating with Judge Silver to get to the bottom of what happened. During that time, I also contacted the Civil Rights Bureau at the New York Attorney General's office and filed a complaint. With no success in either of those attempts of resolving this, I began taking legal action. In each motion to dismiss these three cases, none had direct testimony from Judge Silver. My adversaries presented hearsay from the defendants who I am alleging are the principals and accomplices to the fraud that took place, and their version of events did not include any involvement from Judge Silver. My adversaries had direct access to Judge Silver to obtain a first-hand account from, because he did not retire until September 30th of 2021. To continue, I want to argue my case before a jury and prove that my unlawful discharge from employment was due to a complaint that I made about the very same individuals who removed me, and that these two individuals were not authorized in any way to do so. I want to prove what Young and Shea did was in retaliation for my complaint. Essentially, I want to prove that they acted under color of state law. After being forced into taking unnecessary legal action to regain my job, I now want to prove that neither the federal nor state court system has permitted due process of law for any of the cases that I brought. Each resulting proceeding was conducted counter to established procedure that the courts would normally adhere to, or was simply conducted unlawfully. Due to these factors, each was completely fraudulent. I am also alleging that judges, attorneys from the New York Attorney General's office, and every court employee who became involved also acted under color of state law to engage in what is called a conspiracy against rights, along with crimes as accomplices to the original harm, or participated by violating other established statutes, state laws, and procedures to hide what Young and Shea did. Now that you know why I am suing and why it was necessary for me to pursue these lawsuits, I'll talk about each case a bit more in detail and why I have come to the conclusion that the corresponding proceeding for each case was simply not real, making each proceeding fraudulent, unlawful, and therefore unconstitutional. The first proceeding I will discuss was held in state court for claim number 135085. I commenced my lawsuit at the Court of Claims by filing my claim there in mid-October. 6 days later, the presiding judge, Judge Cece, returned my claim through the mail, along with every copy that I furnished to the court, with a letter stating that the Court of Claims lacked jurisdiction to hear my case. Two months later, an Assistant New York Attorney General, Ellen S. Mendelsohn, filed a motion at the Court of Claims to dismiss the very same claim that was returned to me in the mail. I was baffled as to why the court permitted her to file a motion to dismiss without my claim or an existing lawsuit on file. I went ahead and opposed her motion anyway. The judge reviewed our arguments in absentia and issued a decision in order for a claim that was not only non-existent, but one that had already been established by law was outside of the court's jurisdiction. I'm still not sure what the goal was in conducting this proceeding. What I am sure of is that it was unlawful, fraudulent, and therefore unconstitutional. Next, I will discuss the proceeding that was held in state court for this case, index number 1708 of 2020. I continued to encounter delays with having this case processed. No one at King Civil Supreme Court would answer my questions concerning this case, the status of it, or any other information that someone pursuing a legal action would need to know. So in June of 2021, 1 year after I commenced this lawsuit, I wrote a letter and sent it to the Chief Judge. 2 months later, I learned that Judge Sweeney was assigned to preside over my case. I protested because if what the defendants were saying were true, that Judge Silver made a determination concerning my employment, then Judge Sweeney could not legally preside over my case. The New York Senate website is one resource where you will find the law that Judge Sweeney broke. Judge Silver was the Deputy Chief Administrative Judge for New York City courts. As a trial court judge, this is where Judge Sweeney sits. Not only did Judge Silver supervise Judge Sweeney, and we all know in any profession that a subordinate cannot overturn a decision that his supervisor made, making his assignment to review my case completely improper. Additionally, the law that is outlined on this website states that the original jurisdiction to hear a special proceeding in Article 78 against a Supreme Court justice is here. Due to these factors, Judge Sweeney should never have been assigned to preside over my case. To continue, with the attorney who represented the unified court system and Judge Silver in this proceeding defaulting, and knowing that he lacked jurisdiction, Judge Sweeney went on to summarily dismiss my lawsuit in his decision in order dated February 3rd of 2022. So, this is why I am concluding that all of what happened here makes this proceeding unlawful, fraudulent, and therefore unconstitutional. Next, a federal proceeding for case number CB 7647. After leaving King Civil Supreme Court one day, being very concerned with how the previous case that I just talked about was being managed, I walked over to the federal courthouse and used one of the applications that court provides and filed a complaint. I originally filed this case in the Eastern District of New York. the court assigned my case to Judge Kyo Matsumoto, who, by the way, is the judge that presided over my most recent federal lawsuit. After a few weeks, the court transferred this case to the Southern District of New York and assigned it to the Honorable Vernon S. Broderick. Court staff never explained the reason for the transfer. Sua sponte, the Chief Judge for the Southern District of New York, the Honorable Laura Taylor Swain, ordered that I amend my complaint. In her order, she dismissed my 1983 claim invoking 11th Amendment sovereign immunity. I considered both legal precedent and the ex parte Young doctrine when I wrote my complaint to support the facts and therefore my claims. In similar cases, precedent established that sovereign immunity can only be invoked if one states an official capacity claim. My complaint alleged that the named defendants acted beyond the scope of their duties and engaged in unlawful conduct. The doctrine of ex parte Young stands for the principle that sovereign immunity does not prevent people harmed by state agencies acting in violation of federal law from suing the officials in charge of the agency in their individual capacity for injunctive relief. So, in dismissing my 1983 claim, Chief Judge Taylor Swain positioned my case to be closed and terminated. Shortly after, New York Assistant Attorney General Miranda Onen filed a motion to dismiss. And this is why I have concluded that in this proceeding, legal precedent and the ex parte Young doctrine were eschewed, and procedures that the court would normally adhere to were also disregarded, making it in this instance biased, fraudulent, and therefore unconstitutional. The next proceeding takes place in state court for index number 457 of 2022. I proceeded as a pro se litigant in this lawsuit. The farthest I was able to get was being issued an index number, after which the court system refused to further process this case. Each time I returned to the courthouse for an update, I was given an excuse as to why the case had not moved forward. One excuse was that the clerk processing the case was on vacation. There was no resolution at all. Therefore, I would have to say that the court system impeded due process of law. And this is why I have concluded that what took place entirely in this case has to have been a complete disregard for due process and therefore unconstitutional. Which brings me to my current federal lawsuit, case number CB00656. Judge Kyo Matsumoto was the presiding judge. I commenced this case in January of 2023, and it was April of 2023 that my second amended complaint was served on each of the defendants. There was a pre-motion telephone conference that took place on June 14th of 2023. This has been over 1 year ago now. There was only one topic covered during this pre-motion telephone conference, which solely benefited the defendants, after which I asked the judge to recuse herself. The reasons for my request are outlined in a letter that I sent to the judge, linked below in case you are interested. By November 10th of 2023, all motions to dismiss my case were fully briefed. After enduring all of the misconduct and unnecessary delays, on July 25th, the judge dismissed my case. Neither the judge nor my adversaries have adhered to federal statutes, federal rules of civil procedure, civil practice laws and rules, or the judge's own chamber's practices. And this is why I have concluded that this proceeding has been unlawful, fraudulent, and therefore unconstitutional too. In the end, there was blatant unconstitutional conduct in each of these proceedings that obstructed due process of law. I will appeal the judge's decision and continue to fight. Please comment below and let me know what you think about all of this. I appreciate you taking the time to watch. Thank you.